Hello, Phyllis Roman from Geomaco Law Partners, and today I'm here to talk to you about slip and falls. Now, a lot of people end up slipping and falling at businesses and end up unfortunately getting injured. The question is, can you recover? And if you can recover, what are some defenses that a business may have against your slip and fall? So that's what we're going to talk about in today's video. First, slip and fall. Just because you fall at a business does not mean that they are liable. If you slip and fall because you have been previously injured and you're unsteady on your feet, or if you have low blood sugar and all of a sudden pass out as a result of your own medical condition, the business is not responsible. They have to be negligent. Now the question becomes, what is their negligence? Negligence is, in a slip and fall, a hazardous condition on their property that you have a right to be at. So if you're at a business doing some shopping and there's some sort of hazardous condition that causes your fall, then that business is negligent and could be liable for the damages and injuries that you've sustained. Some examples. Uneven concrete. So a lot of times you'll notice in a parking lot a business will paint yellow or white uneven concrete so that you can visually see the difference. If there is uneven concrete that's the same color and it's clearly cracked and has been there for a period of time, then you slip and trip and fall on that, the business may be liable depending on the conditions. Or another example is if there is a sheet of ice that the business has caused. Let's say they have been cleaning their floors at a restaurant and they take the mop and the bucket of water from the mop and chuck it out into the alleyway, and it creates this sheet of ice that they've created. That could be a reason that they are liable because they've caused that hazardous condition. Another example that I have personally been involved in is grease leaking out of a dumpster. So a lot of times restaurants and things of that nature have two different kinds of dumpsters. One dumpster for food or other trash and just normally what you would think of with a dumpster. And then another dumpster just for grease, essentially oils, things of that nature. There was a case where that dumpster was leaking. It was not contained, the grease wasn't contained, and it was leaking into the alleyway again, but it wasn't something that anyone would expect or that you could see. It was just grease and it made this very slippery conditions, and my client slipped and fell and injured themselves. We held that restaurant accountable for the failure to have a properly working container to get that grease contained in and not leaking and creating a hazardous condition. So, first question, did the business have a hazardous condition on their property, whether they caused it or not? A crack in the concrete, likely not caused by the business, it's just something that happens. So is a hazardous condition on the property? The next question that you would have to ask to see if you have a potential slip and fall injury case is, should the business have known about this condition, or did they know? If it's something that happened 5 seconds before you slip and fall, someone right in front of you dumps a bottle of water in front of you and you slip and fall, it's possible that the business may not be responsible because they had no way of knowing that another customer right in front of you dumped a bottle of water or spilled it, probably didn't dump it, spilled a bottle of water in front of you and then you slipped on that. They had no time to discover the defect. So favorite law school questions of tort professors is whether or not a puddle of water is dirty, indicating it's been there for a long period of time. Or on my own instance, when I went to law school, there was a movie theater with a napkin that was the same color as the floor, and the napkin was very dirty, clearly used, clearly had been stepped on multiple times by people, and and the hypothetical client fell on that napkin. And the question was, is the theater liable? In this instance, the important facts were that the napkin was dirty and had footprints on it and clearly indicated that the theater either knew that that napkin was there or should have known that the napkin and therefore hazardous condition was present. So a lot of times when I have potential clients calling in and they are very confused about my questions, they'll say, I slipped on some water. And I'll say, well, was the water dirty? Was there clearly people had had people walk through it, so there was some smaller puddles as they went. There was juice on the floor. Had it been leaking out or had been spread around? Very strange questions to be asking if you don't realize that the business that you are at, that they need to have known about the condition and failed to remedy that situation, or should have known, other indicating that it had been there for a long period of time and they should have known and remedied that situation. So 2 questions to ask. 1, is there a hazardous condition? 2, did the business know or should it have known about that hazardous condition? Moving on to some defenses that a business may have to your slip and fall. One question is, was the hazardous condition open and obvious? Now, this may or may not preclude your recovery, but it is something that a business owner can utilize to defend against your case. They can say, look, yes, this hazardous condition existed, but that hazardous condition was open and obvious to everyone. It clearly was there. You clearly should have avoided it and not gone through it. For an example, let's say that there was a jar of jelly that just got knocked over, and let's say that the business knew about it and actually had someone going to clean it up, like going back to get a mop and clean it up, and it was bright red strawberry jelly. Okay, then we have a potential client that walks through and just sees that jelly and just steps right through it and ends up falling and injuring themselves. Hazardous condition? Check. Knew or should have known about it? They knew about it? Check. So you would think that the business owner is liable. But the business owner can come back and say, hey, this was open and obvious. There was bright red jelly on top of some white tile. You clearly walked through it when you should have gone around it. That's on you. Your negligence is what, and your failure to look through for around you and see this open and obvious condition caused your injuries. And then it just becomes a debate between reasonable people as to whether or not it was open and obvious. Another example that I have used a lot and that I've actually personally been involved in is when you go to some big box stores, they have the wipes that are available for you to clean the handlebars on the carts so that you're not touching where everyone else has touched and passing along germs. My client had slipped and fallen on one of these napkins, and the business owner tried to state that, hey, it was open and obvious, it's a napkin on the tile. Well, I was able to go in, take one of these cloths, put it on the ground, and take a photo that showed it was white tile, and if it was still a little wet, it basically was invisible. So I took photos and was able to prove that it was a hazardous condition that was not open and obvious to a potential customer, but that the business should have known because they allowed these wipes, essentially, for a better term, to be available for people, and they were often falling on the ground. And so in that case, we ended up recovering for our client because we showed that even though they thought it was open and obvious, when I went to the same store, laid it out, took a photo, it showed that it could not, that it was, could very easily not be seen by my client, just given the lighting and the reflective surfaces of the store. God bless you. The last consideration, I almost always get questions from clients about snow and ice accumulation. This inevitably is what people fall on and inevitably call in and ask to get recovery against whoever owned the business or the location that they were at. Snow and ice are a different consideration. Snow and ice fall everywhere outside. If you were in certain areas like Illinois, you were always going to have snow and ice. The question in Illinois, at least, is it an unnatural accumulation of snow and ice? If you had snowpocalypse like we have here every year, it seems like, and the business is working on shoveling it and working on getting it out, and it's just coming down and it's just there and it's just natural from the snowstorm happening, you likely are not going to be able to recover. It has to be an unnatural accumulation. For example, if you have a gutter from a homeowner that drains directly out into the sidewalk. So you have a gutter where all of the melting snow would empty right onto the sidewalk, and that created an unnatural sheet of ice at that location. homeowner was responsible for someone they had invited on their property because it was an unnatural accumulation of snow and ice that they had created there. If it's just a normal one, unfortunately, you're not going to be able to recover. In summary, slip and falls are extremely fact-specific. You need to know if there was a hazardous condition. You need to know if the business owner knew or should have known about that hazardous condition. Is there a defense that the business owner might have that it's open and obvious and you frankly should have realized it before you went through? There are a lot of considerations that are to be made to determine if you can recover against the business owner. And these are questions that I highly recommend calling up an attorney and asking. You can always call our office, Giamacco Law Partners, at 630-635-5555, and we can walk you through the questions you need to be asking to determine if you can recover from a slip and fall. If you have questions, please feel free to give us a call or any other attorney and to really find out if you are entitled to a recovery from someone that caused or failed to remedy an unnatural hazardous condition. If you have any questions, give us a call, and as always, good luck out there.